Folks, I dropped this book September 2022, White Fear, How the Browning of America is Making White Folks Lose Their Minds. What did I say in this book? They are going to be coming after every single program that they believe gives us an advantage over them, even though nearly everything is for white folks in this country. Well, guess what? It happened on Wednesday. Go to my iPad, Anthony. Federal judge in Texas orders minority business agency open to all races. Now, the Minority Business Development Agency was created under President Richard Nixon. The purpose of this was to assist African Americans and other minorities when it comes to being able to do business with the federal government, providing skills, resources, also access to dollars. Now, the federal government spends upwards, y'all, of $600 billion annually in contracts. Go right to my iPad. In fiscal 2022, MBDA clients secured $1.6 billion in private and government contracts, agency data show. The agency also helped businesses raise $1.2 billion in capital, as well as create or retain roughly 16,000 jobs. Black-owned businesses received $680 million in contracts, the most of any group, followed by Hispanic-owned businesses at $526 million. Now, understand that's 2%. That's less than 2% of federal contracts. Oh, so what do these white conservatives do? They sued. So they argued that, oh, these are discriminatory, and then they give an unfair advantage to certain groups, as if white Americans have not had a massive advantage. So what they did was they filed a suit in Texas. And let me explain to you what they're doing, because they're judge shopping. They are specifically filing lawsuits in places knowing that judge is going to rule in their favor. All of y'all Simple Simon fools who kept telling me I was making too much of a big deal about Biden and Harris appointing federal judges, do you dumbasses now see what I was talking about? This one, again, out of 900 plus federal judges in America, this one federal judge issues this opinion and rules that the MBDA must now serve everybody and not just minorities. Go to my iPad. This judge, Pittman, has emerged as a consistent conservative voice on a range of politically volatile issues. In November 2022, he struck down President Biden's student loan forgiveness program. Months earlier, he set aside a Texas law barring adults younger than 21 from carrying handguns after concluding that age restrictions violated the Second Amendment right to bear arms. Now, here's the deal. If the MBDA under the Commerce Department does not appeal this decision, this goes into effect all across the country. Scholars are now saying, oh, guess what? This ruling could very well change every single federal program that deals with disadvantaged businesses. Oh, I'm not done, Simple Simons out there. Guess what's then going to happen? They're going to go after every state program. Then they're going to go after every county program and every school district program and every city program. They're going to go after every single program. Oh, let's go beyond companies. They're going to go after corporate America. They've already gone after academia. So what they're saying is, oh no, you should be measuring everybody the same, even though white folks have been getting the hookup in everything. But y'all say the judges Biden, Harris, the point don't matter. Oh, Trump gonna fill my pockets with some money, so we gonna roll with him. Stephen Miller, Trump's white nationalist top advisor, he was the one behind the lawsuit that stopped the money going to black farmers. So all you dumbasses running around here talking about Trump, when y'all tell me about Waka Flocka and Lil Wayne and Kodak Black and all of them, don't nobody want to talk about their lawsuits stopping and targeting black people. And you know what they doing, Matt? They are even using the 1964 Civil Rights Act and the 1866 Civil Rights Act against black folks in these lawsuits. Matt?
I was listening to a podcast this morning from the National Constitution Center, and they were talking about the recent decision regarding the insurrection and whether Trump could be barred from the ballot. And one of the contributors on there said something I never heard, but I thought was brilliant. He said litigation as politics. He said that litigation is often used as politics, and that's precisely what's happening here. Your comment on the venue shopping is exactly right with Pittman, especially because what he said here is he said the 14th Amendment Equal Protection Clause essentially bars the MBDA from being able to consider race. But the reason we know that it exists is to make sure that an imbalance is somewhat righted by creating an agency that helps minority business owners. And I think what is so problematic about this, but is so important to your point that you always make, is that, there's just a fundamental presumption that when you step into a judge's courtroom, he or she is supposed to be fair. But the reality is there are lawyers, including me. When I file a lawsuit, I have to consider the venue where I'm filing it, right? If I file in a judge's court where I know she's more inclined to be plaintiff friendly, then I know that may help my client. And that's essentially what they're doing here. But what's scary about it is you have judges who are deciding on bedrock issues and divesting people of longstanding constitutional rights using the same logic that put in place these agencies to support us. And what's scary about this is not only are they going to continue attacking state programs, we're in the Fifth Circuit, the most conservative appellate circuit in the entire country. So the idea that the Fifth Circuit is not going to rubber stamp this is absurd. They are likely going to rubber stamp it. And then you get to a conservative Supreme Court with a 6-3 majority that has already said universities can't use race in their determinations. So the problem with this is it's going to set a precedent, or could set a precedent, where all the programs that are in place to try to right that imbalance to some extent are going to be under attack. And we're going to be going back to before the 1960s and the Warren Court that put in place some of these constitutional rights to help us, or recognize these constitutional rights to give us a fair shot in this country.
So when you look at the suit, Kelly, one is a guy out of Fort Worth. Another is a immigrant from communist Romania. Go to my iPad. Another one is a white man out of Colorado, and then their whole deal is like, oh, they just wanted to be able to grow their businesses, and they all worked hard to get where they are. They all overcame obstacles in pursuit of the American dream. They all cared deeply about their businesses, and they all wanted but couldn't obtain assistance from the same federal program. They're also white, a salient detail in this case. Now, guess what? What Pittman didn't talk about are the programs that the federal government had to benefit women. See, when a Tennessee federal judge ordered changes to the 8A program, it was because a white woman applied. Same thing. I'm looking to grow my business, and I can't use those services. But guess where she actually helped grow her business? Through one of the programs for women, white women. Now, she didn't mind that program, but she sued for the minority program and got that thrown out. That's what we're dealing with. We're going to see these, and I'm telling you, everybody who's watching and listening better buckle up. They are going to go after any and every program in America that tries to offer some assistance to black people and others when we have had to deal with centuries of white racism, white affirmative action, white DEI, white business development programs.
What I find so insidious about this entire situation is the notion that they keep pushing that these programs for minorities is the only way to get business, and that if white people aren't in them, then they are at a disadvantage, when there are plenty of other ways to get business that don't require, frankly, the strenuous processes that are available and have to be done in order to get into that program, to be approved for that program, to get money from that program. So it's insidious in that there's actually an easier way for these white people to get money, and that's just to apply to any other program. But the fact of the matter is they can't stand the thought of black people, of minorities, having any type of advantage, which I don't even like using that word in this context, because it's not even an advantage so much as it is a balancing act. It tips the scale so that everything is relatively equal. I'm not even going to say fully equal, but more equal than it was. And they can't stand the fact that there are people in this country, Black people in this country, who are just as good as them and actually need the help because they've been so disenfranchised. And it just comes off as greedy, as insidious, as seated hatred for Black people as a whole to be as full Americans as white people have already been.
So, Michael, here's what they're trying to say. Oh, well, the categories are just too broad. So they're assuming that this applies to all. And so then they go, well, this doesn't apply to an Oprah. So this is just too broad and unfair.
Yeah, this is a huge backlash to 2 terms of President Barack Obama, and it was unleashed this backlash was unleashed under Donald Trump's administration. Going back to, we can look at September 2020 when Trump was in office, and he did an executive order banning critical race theory being used in training for federal employees. Then he starts attacking the 1619 Project. OK, and September 2020 was 6 months before Christopher Rufo put out his tweet talking about how they were going to redefine what critical race theory was, right, and then start attacking it. So all this is all combined together, and this is trying to attack any programs that are perceived as being beneficial to African Americans. So this is why the judicial branch of government is so important, because they interpret law from the legislative branch of government, and they interpret policies coming from executive branches of government. So we're going to see more of this. And when you had the sisters on from the Fearless Fund, OK, you talked about how we were going to see more of this and how they were going to use that lawsuit from Ed Blum. You said he was really trying to attack corporations. Here we see this attack on the federal government, and for them to use the 14th Amendment, which was created for African Americans, the 14th Amendment of 1868. Now they're trying to use that Reconstruction Constitution against us, and then trying to use the Civil Rights Act of 1866, which allowed African Americans to enter into contracts, legal agreements. That was specifically for African Americans. Now they're trying to use that against us also. So this is why elections have consequences, and why it's important to understand history. And once again, we have to take these people out of power, because it's going to get worse if we don't fight back.